en anglais, mais ça ne devrait pas poser de problème en tout cas à mes étudiants qui sont tous inscrits ici dans le bachelier bilingue français-anglais. Donc pas de problème.
Merci Antoine. Et merci à Antoine et à Jérémy et à François pour l'invitation. C'est un plaisir d'être ici aujourd'hui. Tout d'abord, je dois m'excuser parce que je vais passer au common law, à une perspective du common law, et aussi je vais passer à la langue du common law, à l'anglais. Et je vais commencer, c'est le premier stéréotype. Le deuxième, c'est que je vais être beaucoup plus pratique que nos autres orateurs aujourd'hui. On a entendu beaucoup parler de tous les philosophes juridiques et généraux, d'Aristote, Aristotle. Moi, je vais évoquer seulement un juriste et puis je vais parler un peu de la pratique du pensée par cas dans les systèmes du common law. Mais pour résumer très brièvement en français, de façon préliminaire, je vais parler un petit peu du statut du case law comme source du droit dans les systèmes common law. Parce que ça, c'est la base de réflexion pour les systèmes common law. Dans un premier temps, après, je vais parler de l'utilisation du cas particulier dans l'éducation juridique dans les systèmes du common law. Je vais prendre des exemples des États-Unis et du Royaume-Uni et d'Irlande, d'où je viens. Dans un deuxième temps, je vais parler très brièvement de quelques défis. Comment penser par cas dans le contexte européen, dans le contexte du droit européen, ce qui est un défi commun pour tous les systèmes, toutes les juridictions européennes. Et puis, très brièvement, du mouvement vers l'éducation juridique unique dont Jérémy a parlé. Donc, à l'anglais, et avec mes excuses. I'm going to start with a quotation from Oliver Wendell Holmes, the famous jurist and judge, and he characterized the spirit of the common law in a very captivating phrase. He said that the life of the law has not been logic, it has been experience. And this phrase has been used a lot and relied on over the years to emphasize the distinction between the mode of thinking in the common law, a mode of thinking that is very much grounded in experience, in contrast to the mode of thinking that is said to prevail in the civil law systems, a mode that's much more geared towards logic and centered around logic. And of course, this reflects the nature and development of the common law. It's a system of judge-made law, which is built up gradually over time, as Holmes said, in response to the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, and so on, as opposed to a grand plan that we may see in some of the codes in continental Europe. And this is certainly reflected in the approach to legal education that's taken within the common law world. And I think it explains why there is so much more of an emphasis on thinking by the case and teaching by the case in the common law world as opposed to in the civil law systems. And I think that that's a very useful foundation for our analysis, but it can also be misleading because, of course, it is not just by experience that the common law has developed and that cases are used in educating students within the common law world. That experience is very much tested by logic, tested by reason, in the way we teach cases and so on. And I think that can be forgotten to some extent when we define the two in opposition to each other. And I think that there's probably much more convergence than may initially seem to be the case. So I just, in the paper, I'm going to just briefly set out, and I'm sure this is familiar to many of you, the status of case law as a source of law in the common law system. This is an important distinction between the common law and the civil law worlds. That the case law, judge-made law, is recognized as being a distinct source of law. Now that distinction can be overplayed because, of course, as Jeremy pointed out in his presentation earlier, cases are frequently relied upon in the practice of lawyers and even in the practice of judges in judicial decision-making in civil law systems. But it's still an important distinction, and that distinction is relevant for the role of cases in legal education within the common law world. And that distinction is also still important in an age as Guido Calabresi has described it, an age of statutes, where common law, judge-made law, has become significantly less important. But still, that common law approach, that common law perspective of thinking by the cases, guides how we approach other sources of law, including statutes, including the Constitution, including European law. So just to recap, in the common law system, there is, of course, this doctrine of precedent, of stare decisis, even though it's seen now to characterize the common law. In its formal form, it's actually quite recent. It's a 19th century innovation rather than an earlier innovation. But the doctrine of precedent expresses this idea that past decisions, especially of superior courts, are binding on future courts when they're dealing with cases raising similar facts. And of course, this is rooted in a system of hierarchy of courts, where the lower courts must follow the superior court's judgments, but where even the supreme courts generally have to follow their own judgments in the absence of some exceptional circumstances. That also brings us to the question of what is binding. And here, for law students in the common law world, one of the first challenges is to face this distinction between the ratio decidendi, which Jeremy talked about, and obiter dicta. What's the ratio of a particular case? What are the essential reasons for its decision? Because it's only that element of the case that is binding on future courts, and on lawyers dealing with cases in the future, and judges dealing with cases in the future. Obiter dicta, the by-the-way comments of the courts, are not binding in the same way, but they are persuasive, and depending on the authority of the judge, and the respect in which the court is held, those obiter dicta may be extremely influential indeed. But that's the background against which thinking by the case takes on such importance within the common law world. And it's a fundamental skill and principle of legal method which students must familiarise themselves at the early stages in law school across the common law world. But as that doctrine became hardened and confirmed in the 19th century, it also became overly elaborate in some ways. And the doctrine of precedent, to some extent, became divorced from the practice of lawyers and the practice of courts in actually dealing with real cases. And there's a great degree of flexibility built into the doctrine of precedent because of this distinction between the ratio decidendi on the one hand, and decidendi on the one hand, and the obiter dicta on the other hand, and so on. It explains why case law is so important in the common law reasoning and common law education, but it also highlights one of its weaknesses. When we get too obsessed with trying to divine the reason for the decision, we can lose our overall picture, our sense of the logic, the coherence of the legal system generally, the coherence of a field of law generally. But I just wanted to set that out by way of introduction. But this emphasis on cases, thinking by the cases, is the hallmark of the common law approach to legal education. It differs across the common law world. In the United States, as Jeremy has set out, the case method is the defining, it's being described as the signature pedagogy. It's how law is taught in American law schools, particularly the core law subjects that all students must complete in order to obtain their law degrees. So the case method in the States has become very highly developed and has taken on certain characteristics of its own, which I'll briefly touch upon. But in other jurisdictions, there are different case methods. In all jurisdictions of the common law world, cases are important, but they're not necessarily used in this Socratic case dialogue method that now prevails in the United States. Just to discuss briefly the United States position, there's an interesting distinction between how the United States trains lawyers and how we in Europe and other parts of the world train lawyers. It's a graduate stage of graduate form of legal education. Students have already studied an undergraduate degree in another area. They do 3 years in law school and then they do a bar exam, and on completion of that bar exam, they're fully qualified lawyers. In most continental systems and in other common law systems such as the UK and Ireland, you do your academic legal training at the undergraduate stage, and then you go on to a separate stage of professional legal training. And there's a very different emphasis at those different stages of legal education. Just to talk briefly about the Socratic case dialogue method, which has come to prevail in the United States. But it was initially introduced in Harvard by Langdell, and this was seen as raising the study of law to a new level, putting it on a stronger, firmer intellectual footing, turning law essentially into a science. And the case method has developed, after some initial reluctance, to become the dominant method in all law schools throughout the States. The study of different subjects of private law and public law is based around cases, and in fact not entire cases as we would study in the UK and Ireland, but case summaries. And those case summaries form the basis for vigorous questions and answers between the instructor, the teacher on the one hand, and the students on the other hand, which the students must try to tease out the relevant principles, the relevant rules, the scope of the rules, the possible exceptions to the rules. But they're doing that, and they're doing that not just by reference to the individual case, but by other possible instances, by other more extreme cases, by hard cases, as we heard earlier on, and they're testing it more generally by reference to normal principles of legal reasoning, by logic, and so on. And the epitome of this case law Socratic approach can be seen in a 1970s film, The Paper Chase, which gives a really good example of a first-year Harvard Law student being interrogated on his first day in contract class by his instructor about this case, about lots of different possibilities and permutations and so on. And the case method has gone from a method that was initially designed to raise the profile by law, but also make it useful, make it practical, to a method that is, in many respects, quite divorced from practice, because it's built up such dogma around it itself that it's no longer something that first-year lawyers in a law firm may find particularly useful. And that development is traced in two separate reports which were funded by the Carnegie Foundation. In 1914, the Carnegie Foundation commissioned a report on the case law method, and the author of that report looked at the differences between civil law education and common law education, and pronounced that this case law method was extremely valuable in making students more intellectually focused, but also more practically focused. In a later study that was published in 2007, Educating Lawyers, again published by the Carnegie Foundation, they traced the development over the course of the 20th century. And there they praised the case method on the one hand because it did inculcate within law students this distinctive mode of legal reasoning that characterizes what common law lawyers at least do. But they said that it also had many disadvantages. Because it had become so refined, and because it had become so caught up in a very particular mode of instruction, it was to some extent divorced from the realities of legal practice. So there was a positive assessment in some respects, but there was also a critique of the case method, that it made students think that law could be explained as a system of formal rules without necessarily testing this by reference to the social, political, economic context and so on. So it's kind of a mixed evaluation. In the other parts of the common law world, the approach is much more flexible, but thinking by the case remains a dominant feature. I'll just give you an example from the UK and Ireland, which, while very different legal systems in many respects, share a common legal heritage and share much common ground when it comes to teaching law still today. Where does teaching by the case bring value in legal education in the common law world? And I think there are three or four distinct areas where teaching by the case has a particular value. The first is because for the common law, being able to deal with cases, read cases, analyze cases is a fundamental legal skill. There's that foundational element of developing students' understanding of legal method in the first place. So in terms of method, that's the first way teaching by the case, thinking by the case has a role to play. The second and most obvious one is when it comes to the substance of law, teaching students the legal rules and so on. Now this is obviously particularly important when you come to pure common law subjects. So in our system, certain subjects such as contract law, such as the law of torts, remain based around judge-made law. Judicial decisions are where you will find the relevant legal principles, legal rules, and so on. So the focus of study in those areas is naturally on those key primary sources, cases themselves. But when cases are taught well, it's not just purely about the individual case, and it's not just purely about the experience element. They're tested, as in the US case in the Socratic method, by logic, by general standards of reasoning, moral, legal, and otherwise. So it's, when we define them in opposition, sometimes we can lose that teaching by the case doesn't happen in a vacuum, and teaching by the case isn't something that leaves teachers at large when they're dealing with it. They're also dealing within a certain organizational structure that is defined by certain rules, certain overarching principles, and so on. That applies equally when it comes to other subjects that are not still defined by the common law. So statutory-based subjects such as company law, when we teach them, because of our legal culture, we rely heavily on cases. The areas of the company law code that we're interested in as students and as teachers are those areas that a lot of case law has built up around. Because they're the areas of uncertainty, they're the areas of controversy, they're the areas of most interest. We also see it when we come to public law subjects, such as constitutional law. We've got certain broad normative principles set out in our constitutional text, which have to be defined by real application in cases. So case law plays an important role in all those different areas, but it takes on quite a different role in each of those areas. In the pure common law subjects, it's the proper thinking by the case, divining the rules, finding the rules within those cases. But in other areas, it's elucidating statute and constitutions by reference to the cases, a method which I think is probably quite similar to that applies in the civil law systems. So that's just by way of a general overview. What are the advantages then for lawyers and for training lawyers when we come to the overall theme of this seminar? And some of them I've already touched upon in terms of developing method, but also learning the substance of the law in an engaging way. And that's where we come back to something that Francois touched upon in terms of law as a story. And I think for students to make law, legal rules, legal principles more interesting and more engaging, knowing the participants that are involved, knowing the human faces behind the decision that you're reading is a really important element which can bring the law to life. And I think that the emphasis on cases in the common law world can certainly help in that regard. But there's another two elements that are also important. They give an insight into procedure and into the legal process, how the legal system works in practice, which if we're just looking at the rules in the code or in the statute, we can easily forget about it. But that's an essential element for a complete picture of the law. And finally, the emphasis in cases can help us better understand the social, economic, and political context in which law operates. And that's particularly so, for example, in an area such as constitutional law, where you know the individual cases that might direct a court to decide on the scope of a right in a particular way. That can make you understand what are the legitimate bounds of judicial lawmaking and what are the limits to judicial lawmaking, to return to a theme that came up earlier. But the approach is not without its limitations. And some of the disadvantages have already been alluded to in the context of the Carnegie report, that the case method has become overly elaborate, overly defined, and has become quite divorced from practice. Another critique in the Carnegie report is that it doesn't adequately develop students' broader skills, such as skills, social skills and ethical skills, which are also essential for one's training as a lawyer. So there are some of the limitations, and there are many others as well which we can come upon, but I don't want to dwell on them too much. I just want to raise two questions to finish. These are two of the challenges that we face as we modify the case law method to the contemporary context. The first relates to European law. How should we teach European law? And I think when you look at the core texts on European law, in the common law world on the one hand, and the civil law world on the other hand, and civil law jurisdictions, you see quite a distinction. In the civil law treatment of EU law, you see the European treaties and European law laid out in a very systematic, schematic way. When you look at the common law text, there's emphasis more on themes and cases. Cases are front and center when it comes to treating EU law in many of the common law texts and treatments. And of course that's an overgeneralization, but I think it's an interesting issue for us to reflect upon, because that's a common challenge for all jurisdictions across Europe. And I think certainly, and this may be my common law bias coming in, it's difficult to see how you can really teach a subject such as EU law or the law of the ECHR without very detailed thinking by the cases, because the cases shape that law, both those bodies of law, in a really fundamental way. The second reflection is how, in response to some of the limitations of the case method, we may need to move, and certainly in the US and in other parts of the common law world, and even in other areas of continental Europe, such as in France and Belgium and so on, there's a movement towards a much more practically focused form of legal education, where pensée par cas takes on this new meaning that Jeremy has talked about. It's not thinking about cases in the case method way, it's actually dealing with, engaging with real cases. And I think that where that's important is the case method that's defined around the doctrine of precedent, that centers around stare decisis and the rules and the decisions of superior courts, often gives you a very unrepresentative view of the law. You're looking at decisions after they've gone through a number of different steps in the court systems in a very refined form, where all the facts are decided, where the legal issues are narrowed down in a very radical way. And then when you go to practice, you're left lost and a little bit bewildered, because that's not how cases are when you find them. When they come into Jeremy's clinic, when they come into you in your law office, if you go on to become a practitioner, it's very different. You're getting cases in a much more uncompartmentalized, unrefined form. And I think that explains this reflex and this movement towards more practically focused legal education. And I think that question brings us back to the fundamental question underpinning these seminars, which is, what are law schools to do? What role should law schools take on? Are law schools there to train lawyers, to train really good practicing lawyers? Or are they there to focus on the intellectual pursuit of law as being of interest and of benefit in itself? And I think that's a struggle that many law schools here and in the US, and Jeremy alluded to the crisis in legal education in the US, that's a common struggle that we're all facing and that we all have to grapple with against this changing background. So I'll just conclude on that, and again, thank you very much for your patience and for the invitation to come here today.
Merci beaucoup David, je crois que c'était très clair et ce qui était à mon avis assez